Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. I'm here with Ann Lipton, law professor, Tulane, New Orleans, you know it all, who teaches and researches securities and business law. She holds up and talks intelligently about the legal end of our podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
Or I try to. I probably don't do as well on the financial side as you do on the legal side, but that's fine. This week, let's return to Delaware, though not in person. When's the last time you were in Delaware?
Okay, I confess, I have never physically set
You've never set foot in Delaware? There's
the
conferences
state.
there and so forth. That
They don't know. I mean, there are some, but the conferences, I go to New York, I go to Boston, I go to Philadelphia, but I've never, it's embarrassing.
Because, you know, that's the joke I tell when you're not here, is you're at some conference someplace.
I very often am, but it's not a conference in Delaware. It's really
Fine. Well, last time I was in Delaware, everybody here knows, is I was arguing my objection in Detroit v. Tesla, which we can talk about on the podcast, and that was a year and a half ago. So I've been there more than you have. Oh, that's interesting.
Yeah, I know. I mean, I might have driven through or something, but that's not impossible. Or taken a train that passed through.
Right. That was my experience up until October of 23, when I driven through and so forth. But I spent 2 days in Wilmington. It was kind of interesting. Anyway, we're going to return to Delaware in spirit and intellectually. And we're going to talk about the outcome of the very brief but very intense process that the state put itself through to change the statute there that pertains to Section 144, that pertains to conflicts and independence, and also the part of the statute 220 that pertains to books and records. And there's potentially far-ranging impacts that people have been cogitating about, both of those amendments themselves and also of the process that Delaware went through to kind of get there.
Yeah.
So when we last talked about this, I think about 4 weeks ago, when the bill had just been introduced, SB 21.
Yeah, it had just been introduced.
And it was going to really dramatically change it. So what happened in those past 3-4 weeks? Maybe let's talk about what happened to the law, and then we can talk about everything else.
Yeah. So last time we talked about it, the bill had just been introduced about February 17th or so. And right after we recorded that episode, before it even became public, some amendments were made to the bill. So it changed a little bit from what we described in our podcast. And that new bill with those amendments was the one that actually ended up passing into law. So I'll talk a little bit about what the final law looks like. And I'll highlight how it changed from the way we described it originally when we talked about it. So just background, we've said this many times on the show.
Yes.
One thing about Delaware that corporate law does is it oversees conflicted transactions when the company does business with one of its own directors or officers or a controlling shareholder. So a lot of potential in those cases for the insider to exploit the company. And so if a shareholder brings a lawsuit over that kind of contract, Delaware courts will examine it very closely to determine whether it's entirely fair to shareholders, which is a very searching inquiry. Now, sometimes, I got to say, when there's entire fairness as an examination, sometimes the companies win. They prove that the conflicted transaction was entirely fair.
It was a fair outcome, fair process.
Exactly. Like when Elon Musk caused Tesla to buy Solar City, that went to a trial, and the court concluded that that was fair to the Tesla shareholders. The Tesla shareholders said they paid an inflated price for Elon Musk's other company, Solar City, and they lost. The court said it was entirely fair. But usually companies, they just don't want to even go to the trial. Like even if they're going to win at the trial and they may lose, they don't even want that trouble. Right, exactly. So the way that you avoid that is you cleanse the deal, meaning they have an independent decision maker approve the transaction before it gets to a courtroom. That decision maker usually means the board or a committee of the board that's independent. Or you could take it to a shareholder vote and have the disinterested shareholders approve it. And if you do that,
disinterested shareholders are the ones not including
exactly the ones not
the conflicted directors or the CEO or the other investors or whatever. They can't vote on it.
Yeah, that's usually the way it's done. So if you cleanse it where the disinterested shareholders actually vote in favor of it, or you have the independent board approve it, the court won't examine the transaction further, even if there's a lawsuit. So that's sort of the basic setup.
Now, was Solar City cleansed? I don't think it was.
It wasn't because
Right.
the issue was the shareholders voted. I believe the Tesla, if I recall correctly, the issue was that Elon Musk was deemed was possibly a controlling shareholder.
Yes.
And given that, it wasn't like the court didn't decide whether it was a controlling shareholder. They said that it was. They didn't have to ask whether it was cleansed because they said it was entirely fair. It was a whole thing where it wasn't sure how you would cleanse it, but it was entirely fair, and so the court didn't have to go into it. That's
right. Cool.
Anyway, so this new, as I said, one way that you cleanse it is by having independent directors approved. So the new legislation, the first thing they do is change how courts will evaluate whether the directors were independent for the purposes of cleansing. Under the new law, if the company designates a board member as independent under exchange listing rules, that board member is presumed independent unless the shareholder puts forth some fairly detailed evidence that they aren't. And that was true in the original version. The amendments in the final bill, there's a little tweak. The problem with the original legislation is that exchange listing rules only ask if someone is independent from the company. They don't really ask whether someone's independent from the other directors of the other interested parties. And that's the relevant question. When shareholders bring a lawsuit, in the context of the lawsuit, the question isn't whether a director is independent from the company, which is what the exchange listing rules are about. The question is whether a director is independent from whoever the conflicted person is, so that the director can make a fair decision about that person. So the final law kind of acknowledges this by saying if the transaction involves a controlling shareholder, we'll take the exchange standards for independence from the company and ask if those same standards work for the director with respect to the controlling shareholder, so that a particular director can be deemed independent from that controlling shareholder using the exchange standards as if the controlling shareholder were the company.
Like, so we're applying those standards to the CEO or the
right, exactly, to the controlling shareholder, but it only controlling shareholder, but it doesn't change a whole lot, but it just raises more questions. I mean, the whole theory of the original one is when you trade on an exchange, companies are required to designate, we think these are the independent directors. They do that in advance. They do that before any conflicted transactions. They do that before any shareholder brings a lawsuit. They say, these are the directors who we think are independent. So the theory was if a shareholder comes along and brings a lawsuit, those directors are sort of presumed independent and the shareholder has to rebut it with some detailed evidence. But the exchanges don't require you to do an evaluation of whether directors are independent from the controlling shareholder. Like that's not...
That's not how the exchanges think about this. They're only thinking about the company.
They don't even think about control in the same way. So what I can't tell from this legislation is if shareholder brings a lawsuit and the question is whether a director is independent from the controlling shareholder, do the boards make a determination in the first instant and there's a presumption, or does the court just examine it? I mean, it's really unclear what we're doing here. Like, I can't even tell whether there's the same presumption or whether the board gets to make a designation. Does the board get to make a designation in advance? Does it do it? I have no idea what this legislation is doing.
In the middle, you're right.
I don't know what's envisioned here. But this all gets back to something that we talked about last time, which is this is Delaware functionally outsourcing its independent standards to federal law, to the exchanges.
To the exchange. Well, it's to the SEC, which blesses the exchanges, and basically the SEC delegates independence to the exchanges, essentially.
Exactly. The exchanges make their rules. The SEC approves it. There's this relationship. So Delaware has always held itself out as the expert on corporate governance. It sets the standards. Others follow. So to let federal law, the exchanges, make this determination in the first instance, I mean, it's just an extraordinary retreat by the state. So that's the first thing that the legislation.
All right. So there's the independence issue. Right. All right. Go ahead.
Okay. And now I get to this cleansing. So let's assume no controlling shareholder is involved. Assume the problem is there's some conflict among the directors. There's no single controlling shareholder. So the usual rule is you can either cleanse by having independent board members approve it or cleanse by having the shareholders approve it. Let's talk about shareholders first.
Shareholders approve it in a vote.
Yeah, in a vote. Like you put you put out a proxy statement, you put it to a shareholder vote. So both the original bill and the revised version allow for conflicted transactions to be cleansed by a shareholder vote, which has always been the rule. But there's been a critical change. The original version specified that shareholders had to know the material facts of the transaction and specifically had to know what these directors' involvement in, how they were involved in negotiating it, what their interest was, all that had to be disclosed. That was just taken out. Now it says
wow.
the shareholders have to be informed. That's all it says. Now, if there's board approval, we'll get to board approval. If there's board approval rather than shareholder approval, the board, according to the statute, has to know the material facts, the role of the interested directors in negotiations, all that. But for shareholders, they took out that shareholders had to know how the interested directors were interested in what their negotiations were. It deleted that language. And now it just says shareholders have to be informed.
So that was an amendment to SB 21.
It was an amendment
that
to
sounds
SB
like
21.
it made it kind of worse.
Exactly. It made it worse. So let me explain why it's significant. Before any of this legislation, there were a lot of cases where shareholders voted to approve a deal. But then after the fact, when there was litigation, the court held that the shareholder vote wasn't informed because the shareholders weren't told about defects in the process by which the deal was negotiated.
There were like some directors knew each other or
exactly.
conflicted.
There were conflicted advisors. Yeah,
Yeah.
Conflicted advisors was a big one. And this is what happened with the Elon Musk pay package. The shareholders were told, like they knew the economic terms of what his pay package was,
right.
But the court found they weren't told about how Musk interfered with all the board deliberations. And in these cases, defendants have argued, and this is what Musk is arguing right now before the Delaware Supreme Court in his appeal of the pay package decision. The defendants argue that it's fine if shareholders only know the economic terms. They don't need to know all the details of how the deal was negotiated.
Of how they got there.
Right. So the original version of this
That's
bill...
awful. That's,
exactly.
Oh my God.
It's terrible. It's so terrible. The original version of this bill...
I need to know that.
Exactly. The original version basically followed existing law. The new version takes all that out. Now, it doesn't say shareholders don't have to know it. It does say they have to be informed. And if you know...
Right. Informed is really vague here. Informed could be anything.
Exactly. So I think that's what this revised statute is trying to do. It doesn't say it explicitly, but I think that removing the language requiring shareholders had to know all the facts about how this was negotiated, I think... they're teeing up an argument, if this ever gets to a court, that shareholder approval is sufficient even if the shareholders don't have all the
it doesn't matter what shareholders saw what they're voting on. As long as shareholders voted, it didn't matter.
Yeah, exactly. Now, we'll see if courts view it that way. I mean, maybe we'll see if any case even gets to a court, which at this point I doubt. But I think that's why the language changed. The defendants have been very unhappy with these rulings where shareholder votes were rejected because they didn't know all the process. And I think this is a way of trying to undo that line of case law. So that's what it does about shareholder votes.
All right.
Then we get to cleansing at the board level. In the original bill, even if a majority of the board was conflicted, you didn't actually need to use a committee. The entire board could deliberate together, and the transaction would be cleansed if of this entire board, this majority conflicted board, if of the independent directors who were on the board, a majority of those voted to approve it, the deal would be cleansed. So imagine you had a 9-member board with a single unconflicted director. If the whole board voted in favor of the deal, 8 conflicted ones.
8 to 1.
And
right.
8 to 1, but that one unconflicted vote voted with the majority. If they voted with it, then the deal would be cleansed because a majority of the disinterested directors, the one guy, voted in favor. That was the original law. That's not the new one. Under the new one, the law as it actually passed, if a majority of the board is conflicted, the board has to create a committee to approve the deal.
Oh, this is a committee of 2 or something.
Yeah, and the committee has to have at least 2 people on it. And they all have to be independent, which sounds really good. It sounds stronger than existing Delaware law, because under existing law, we had a whole show about you can have 1-person committees.
Right.
And under existing law, if you had more than 1-person committee, it just had to be majority independent. The new law says you have to appoint a committee that's entirely independent. But there's a catch, because there's always a catch.
Okay, there's always a catch.
This is the catch. When the board puts the committee together, the board has to name 2 people, and the board has to determine that at least 2 people, the board has to determine that those people are independent. But if a shareholder comes along and proves that they weren't independent, the transaction is still cleansed, so long as a majority of the actually independent committee members approve the deal. In other words, the board has to choose the ones it thinks. This conflicted board, by the way, it's a majority conflicted board. It creates the committee. It gets to decide who it thinks are disinterested, but there's essentially no penalty if they're wrong. So let's say this majority conflicted board creates a 3-person committee. The board, this majority conflicted board, has to make a judgment call that those 3 are independent. Right. Those 3, let's say, they unanimously approve a deal. If a shareholder later comes along and proves that 2 of them were not independent, So this was a majority conflicted committee. The deal is still cleansed so long as that one remaining one, the one who was actually independent, voted in favor.
Voted in favor.
Yeah. So, I mean, what this looks like to me, honestly, is that the corporations or their lawyers said, well, this is what boards do ordinarily, so let's make it so that shareholders can't ever sue. We'll take existing practice and inscribe it as okay into law. Because most of the time when boards create committees, they usually do have committees with at least two people. One-person committees are kind of rare. So they usually create two-person committees at least. And they usually probably make an effort to make sure that the people they put on the committee aren't obviously conflicted. And so the law says, as long as you do that, as long as you do what you are always going to do anyway, which is create a multi-member committee of the people who weren't obviously conflicted, we're making it virtually impossible for shareholders to challenge it. So that's how you deal with board-level conflict, if board-level conflicts. It's committee approval or shareholder approval.
Right, and it's either or. Previously, under most situations, it was both.
No, that was for controlling shareholders.
Or controlling shareholders.
Which we're getting to. But they take that, that also. Right, so there was always either or. What they've done is they've weakened what either one of those look like by weakening the information standards for shareholders and weakening the committee structure for boards.
That's a great point. So, all right, yeah.
And then we get to controlling shareholders. So under the old Delaware law, control was this indeterminate concept. You were definitely a controller if you had 50% of the votes. If you didn't have 50% of the votes, you might be a controller if you functionally, with voting power or contractual power or even just star power, you had the ability to control the board. And under that law, first, we would say that controlling shareholders owe fiduciary duties to the entity. They couldn't just use their power to benefit themselves at the minority shareholders' expense.
Right.
And second, if the deal involved a conflicted controller, it had to be negotiated by a completely independent committee, and separately, it had to be approved by the disinterested shareholders who were fully informed of all material facts. Well, the new law mostly changes that. First, it defines controller very narrowly. 50% of the votes, you're a controller. That's still true. And if you have a contractual power, because Delaware now allows these really overruling
under the Moelis business.
Exactly, the overruling of Moelis. If you have contractual power to seat a majority of the directors, then you're a controller, and that part is new. It was just added in the recent
so that was part of the amendment to SB 21.
Yeah, that was part of the amendment.
Okay.
But if neither of those things are true, you don't have 50% of the votes and you don't have contractual power to seat a majority of the directors. The only way you can be a controller is if you have at least 1/3 of the voting power. Plus, you have to be able to exert some control over the board.
Wow.
And as we said last time, that means that if you have a stockholder agreement that gives you functional control over all board decisions, which again, now possible.
Which now is totally legit.
Now,
right.
if you have a stockholder agreement that gives you control over all board decisions, as long as you don't actually have 1/3 of the voting power and you can't seat a majority of the board, you're not a controller.
You will never be a controller.
Exactly, which means you don't have a fiduciary duty to the company. You can exert control selfishly. You can cause the company to engage in conflicted transactions.
You could do all sorts of, you could spend money wantonly.
Exactly, without regard to whether it harms the other stockholders. And if you do have a conflicted transaction, and I don't even know if you count it as a conflict because you don't count as fiduciary, if you do have a conflicted transactions, you get this same ordinary cleansing procedure that we just talked about.
Right.
The board alone or shareholders alone.
One or the other.
Well, I mean, if there are conflicted transactions, if you count as a controlling shareholder. If you don't count as a controlling shareholder, I don't even know if it's a controlling shareholder. But anyway, so what this means, I mean, as a practical matter, is it encourages the use of shareholder agreements. I mean, why would you risk being designated a controlling shareholder with fiduciary obligations and conflicts, and you have to cleanse the conflict some way? Why would you even go through that if you can just have power, the same kind of power, but not be designated a controlling shareholder? So I think that, honestly, from an academic perspective, what I expect to see is really interesting empirical work about companies going public now under the new law and whether they eschew dual class structures in favor of shareholder agreements, because that way they can make sure that they're not controlling shareholders.
That's an interesting prediction.
Yeah. So, and they're not subject to any additional procedure at all. So anyway, so that's the first thing. Delaware now defines controlling shareholder extremely narrowly. But now let's say you are a controlling shareholder because you have majority voting power or whatever. Under the original standards, as we said, you needed the board approval and
before SB 21.
Before all of this, exactly. You needed both board approval and shareholder approval before a conflict transaction to be cleansed. Under the new law, though, The only time you need both board approval and shareholder approval is for a go private.
For a buyout.
Exactly.
Right, from when we're taking you
private. The controlling
private.
shareholder is buying out the minority shareholders and delisting the company. Any other conflicted transaction for a controlling shareholder only requires the same, either one, board committee approval or shareholder approval on the same standards that we just talked about with this weird thing.
Which are really which are lower now.
Exactly.
Right.
You just need one. So this is why I think it's interesting. If you compare the law that passed to the original bill that was proposed, the new bill seems stronger because it has this thing about the board committee has to have 2 people on it. But the old bill at least required that the committee had to be majority disinterested, like actually majority unconflicted. Whereas the new bill has this wacky, well, the board determines that they're independent, but then if it turns out they're not independent, it's kind of okay. So the version that actually passed adds a lot of extra procedure, but in fact makes it a lot easier to cleanse deals, including with this lessened, weakened shareholder information requirement.
Wow.
And then, of course, if it's a go private, you need both triggers.
Right, and that's very clear in that's right.
Yeah, and just to be clear, one example, by the way, of right now there's this Paramount transaction that's pending.
Oh, Paramount with Sherry Redstone and all.
With Sherry Redstone, she's a controlling shareholder. She's being bought out by Skydance, and it's different consideration.
Which is Larry Ellison's kid.
Exactly. She's getting paid more consideration than the minority shareholders. That is a conflicted transaction, but it's not a go private. So if the new standards were to apply to this one, you would only need one trigger: board committee approval or shareholder approval. That's how narrow this is for in terms of protections. And the last substantive thing in the new standard is books and records. The original version of the bill wouldn't have allowed shareholders to obtain informal materials like emails, like contracts.
Internal communication, basically.
Yeah, all those internal communications that didn't circulate formally in the board meeting. The new version, actually, this is a real change. It will allow shareholders to get those materials, but it sets this extremely high bar for shareholders to get them.
In terms of proper purpose.
Yeah, they have to show, like with specificity, a really high need for it and so forth.
Right.
And the final thing is retroactivity. The original version of the bill didn't say whether it would apply to pending cases, and whenever the legislators talked about it,
pending cases like Tornado v. Musk,
that pending
Elon
case, Musk's pay package appeal,
that pending case,
like the Paramount merger. The original version of the bill didn't say whether it would apply to pending cases, and whenever the legislators talked about it, they were really cagey.
They were a little coy.
Yeah. So this bill went through the edits, and there were still games. So at first, the amendment said the new law would not apply to any cases that had been filed as of the date the original bill was introduced, February 17th. So under that standard, it doesn't apply to the current pending cases against Musk, including the pay package case.
Right.
But then, originally, they actually included a note, and they said, this bill doesn't apply to pending cases, but of course, courts should feel free to take the standards in the bill as a statement of existing
it was like
law.
A wink, hint, hint to the Supreme Court.
So they said it's not retroactive, but it is. And then they took out that little note, but everyone saw it. I mean, we can all remember it. So the end result is that pending cases are not affected. The pending lawsuits against Elon Musk are not affected. But any new cases filed since the introduction of the original bill, February 17th, those are subject to the new law.
And that's pretty clear, I think.
Yeah, that's clear. But, I mean, this is such an incredible slap in the face to the judiciary. I mean, I think it'll be difficult for them to look at pending cases and just ignore how much their entire approach over 40 or 50 years has been rejected by the legislature. I mean, I think for sure the judges are going to try to decide the cases before them based on the law that applies to those cases. But I think it's going to be hard for them to just escape psychologically.
Right, they're sort of in their subconscious. There's this new law.
Exactly, and then they're you don't know which way that cuts. Like on the one hand, they don't want to apply the new standards prematurely, but on the other hand, they took a rebuke. But on the other hand, they don't want to try too hard to respond. Like you could totally see it. I don't know which way it cuts, but I think it puts the courts in a very difficult position because the message being sent here is, shareholders should never win lawsuits. That's the collective effect of these changes. They're telling courts, dismiss the cases. And that's hard for courts to ignore, even for the cases that are not technically subject to the new law.
Right. There's this kind of worry, like I said, in the background that, what if we kind of don't follow this, what are they going to do next?
Yeah, exactly.
So, all right. So let's talk about a couple things and take a break. There were some things that were proposed legally or
Yeah.
legislatively or statutorily that were not adopted that seem to kind of respond. And we'll talk about the hue and cry in Delaware over all the politics a little later. But for now, what was proposed and declined or rejected?
Okay, so there was a lot that was proposed and rejected, and when you hear like how sane it was and how much they rejected it, it's really interesting. So one proposal was to expand this dual protection thing. So we just said that the dual protections for controlling shareholder deals, and control defined very narrowly, but if it's a controlling shareholder conflict, you only require both board approval and shareholder approval if it's a go private. So one proposal would have said, how about for all extraordinary transactions? Any place where it's a reorganization or the existing shareholders are losing their stock. Like, so there was a proposal like the Paramount deal. Like, if the Paramount deal were subject to this new law, as I just said, it would only require one layer of protection. So the proposal was, what about those kinds of extraordinary things? Why don't we make all of those subject to the dual protections? That was rejected. There was another that would have changed the effective date. So the law that passed doesn't apply to pending cases, but it does apply to any new cases filed, even if those cases concern older transactions. So that means if there are deals out there that right now plaintiffs have been investigating, getting ready to file a lawsuit, they're going to be subject to the new law. So there was a proposal that said, how about we have it so that the law only applies to transactions that happen after the effective date or after.
Right, so they could sue within the statute of limitations next year.
Right. So, but no, that was rejected. So right now there are like cases where, for example, shareholders may have already made a books and records demand, they're already investigating, but if they file a lawsuit now, it's going to be subject to the new law. And because that proposal was rejected. Another amendment was proposed to change the committee thing so that the boards would have to actually be disinterested, that there wouldn't be this weird situation where the board decides if they're disinterested, and if it turns out they're not, it's okay anyway. They wanted to make it so that the committees actually had to be unconflicted. That was rejected. But the proposal that got the most traction was to make the whole law opt-in, meaning if companies wanted to be subject to this new lighter regime, they'd have to actually adopt a charter amendment that explicitly said, yes, we like this lighter standard of review for conflicted transactions. And a charter amendment, of course, requires a shareholder vote. Right. So now the original proposal was, since charter amendments require a shareholder vote, well, the issue there is like, what if it's a controlled company? What if it's like Facebook? I can't call it Meta. What if it's Facebook, where Mark Zuckerberg, like, he controls the votes and he'll control to give himself a free pass. So the original proposal said that if it's a controlled company, then the minority shareholders
a majority of the minority have to approve that charter.
Exactly. So that was so it's functionally the minority shareholders would have to agree to lose their litigation rights, and if it was an uncontrolled company, then you just have a shareholder vote. But that wasn't getting any support, so the proposal was changed to just require a straight charter amendment shareholder vote with no majority of the minority condition, meaning that if it's a controlled company, they could just sort of force the change through unilaterally. And the argument in favor of that was, well, all these changes to Delaware law are being made ostensibly to prevent companies from reincorporating out of Delaware. Well, reincorporation requires a shareholder vote. So instead of giving company insiders all this blanket immunity, we'll give them a choice. They can have a shareholder vote to reincorporate out. And if they're controlled, the controller controls that vote. But either way, they have to have the vote. Or they can have a shareholder vote to just adopt these changes. The theory was it's the same process, so we may as well just make it opt-in for this lighter review regime. But nope, that was rejected too. And it actually got kind of testy. An NYU law professor was testifying in favor of an opt-in regime.
Was that Jackson, I think?
That was Robert Jackson. He was a former SEC commissioner. The House Speaker in Delaware actually shouted at him to leave the podium. I mean, if you watch the video, it's actually a really shocking moment.
It's bad.
And I gotta say, it comes out of nowhere. I'm really disappointed that no opt-in proposal succeeded, because I'm really curious how that vote
how many would opt in and how would they do it? Yeah, right.
Exactly.
It's an interesting question.
We've said before, plenty of people argue that shareholder litigation just isn't valuable. That even if they'll agree that this case was really beneficial, but they'll say in the main, given how many nuisance suits are filed, given the cost of D&O liability insurance and all of that, it's just not worth it to have shareholder litigation be a thing. So I really wanted to see what shareholders thought, like especially the big mutual funds like BlackRock and Vanguard. Did they agree that shareholder litigation has no value? Would they have voted in favor of this later regime? But we never know, or at least we won't know directly, because the opt-in proposal was rejected.
And that would have been the perfect illustration. I can't think of a better example of private ordering.
Exactly.
Of applying private ordering to a company, which is what, a lot of folks really
say they
kind
want,
of pushing
but
for.
No, they say they want private ordering, but I think this was another way of protecting insiders, because the thing about an opt-in is like the optics of it. It would mean that the corporate managers, the Mark Zuckerbergs of the world, would have to
they have to subject themselves to this vote.
Exactly. They have to affirmatively go to their shareholders and say, we want to be completely free to engage in conflicted transactions without judicial oversight. They'd have to explicitly make that statement.
Vote for me, please.
Yeah, and even if the vote outcome was certain, like at Facebook, it's embarrassing to say to shareholders, hey, we're affirmatively choosing to be able to freely engage in conflicted deals. So they launder this through the Delaware legislature. I mean, everyone knows that corporate managers and their law firms were kind of bullying these changes through, but this way they don't have to actually go out and put their names on it in a proxy statement. So the opt-in proposal was rejected.
All right. So we've got the original bill we've talked about. We talked about all these amendments. In a couple of small ways, the amendments improved a little bit. In most ways, it made it somewhat worse. There were a whole bunch of proposals. As the politics got heated, none of them were adopted.
None were adopted.
And now here we are with a much weaker set of controls over what it means to be independent and what it means to be a controller and how their interests are subject to much less scrutiny now, basically.
Yeah.
All right, let's talk in a minute about what all this means, like for shareholders and for activists and for the state and so forth. But let's take a break first. How's that sound? All right. Cool. We'll do that and talk more about Delaware here at Shareholder Primacy.
Shareholder Primacy is brought to you by FreeFlowAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFlowAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFlowAnalytics.com. Now, back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin. So we'll continue looking at what happened in Delaware and what it means for companies, activists, shareholders, and Delaware itself.
Yes, we will. I had a couple of observations as more of an investor looking at this, I didn't follow every twist and turn. I tried to, and it got really hairy. trying to, and there were all sorts of good resources. Chancery Daily,
Chancery Daily, they
give them a shout out.
With just everything,
some others. So I got lost after a while. So that's why I was really eager to kind of hear from you exactly what to pay attention to. But I still have some thoughts. One of the first comments is it's still early. The ink is like wet on this thing. Mm-hmm. It was only approved in a vote last Thursday night, I think, right?
It was yes. Well, honestly, I forget, but it's something like that. And no, was it Tuesday? Honestly, I don't remember. I think it was Tuesday. But the governor then flew in to Dover immediately, had to travel across the state, which is it's not a big state, but they had to travel across the state so he could sign it that evening.
Right, and I think it was signed. I thought Thursday night. No, so as we're taping this on the weekend, the thing is 2 or 3 days old. Yeah. And the point there is there's a lot more to interpret about it. There's going to be some cases we can talk about. There's going to be all sorts of twists and turns. So anything we kind of say here is probably based on very informed speculation about what's going to happen rather than, for sure, there's going to be more.
I think this is going to kill shareholder litigation, or at least fiduciary litigation, but, proponents keep insisting that is not true, so we shall see.
Right.
It's hard
exactly.
The pending cases are...
I love your point about how we're going to shift away from dual class shares and more to just shareholder agreements. Why would you risk having all these dual class shares and counting votes in all sorts of fun ways and not just have a shareholder agreement that just sort of gives the founder or whatever some rights that wouldn't normally be found. And then the second point is there's still going to be some cases. This new statute or these amendments are going to have to be tested. Yeah. And so it's probably going to take some time, we think. And part of the problem is that based on what we sort of saw in the political debate is we don't even know who's going to take on cases challenging this. That's one of the big risks, is it's potentially that a lot of the firms that would normally take on a company or try to challenge a conflicted transaction or something may not even want to try.
Yeah, I mean, well, it's expensive. It's an expensive proposition for plaintiffs, and they don't get paid unless they win. So it's between the actual standards and the message being sent to the judiciary create the prospects for winning seem rather dim.
Seem somewhat lower, and that was the point. And I'll get to that. I'll get to that point in a minute. It did seem, and we've talked about this before, and there was all sorts of observation, all sorts of news reporting, that this was an unbelievably politicized process. Very unusual. We talked about this before, that usually the Delaware legislature just rubber stamps what the state bar puts in front of them. Mm-hmm. And that absolutely did not happen. And there's more and more evidence that was coming out that not only was the firm that defended Tesla involved, but that Meta was very heavily involved in the drafting of this. And the observation, and I don't know if you know, when I was this is in the 80s, I worked in the state legislature in Illinois. Oh, okay. And for 6 months. And I got to say, state legislatures can be really kind of backwards places to kind of get stuff done, okay? And I would guess, given the history in Delaware of the legislature probably doing other stuff that matters to the residents of the good state of Delaware, but not really having much to do with corporate law, that they were like a rich, soft target. That it was kind of a sleepy set of lawmakers who really didn't have a whole lot of experience.
Most of them don't know corporate law at all, and that's why. Right. I mean, you got to understand that's kind of why that was always viewed as the strength. The theory was they don't really have much of an industry. They're a tiny state. They don't have that much. That actually means that we take the politics out of corporate law and leave it with
that was part of the point.
That was the theory.
And so you get a bunch of legislators that are looking at billions of dollars in franchise fees. Mm. And you had some corporate interests that kind of swooped in on them and said, this is all at risk. Yep. There's Walmart's even considering that was some news report. Walmart's going to change their domicile and so forth. Exactly. Right. And so, setting aside, Walmart would have to have a shareholder vote to approve that. I don't know if they'd win it.
They have their controlled company, they would win it. Because
Walmart, yes. Okay, fine. Great. Walmart family. Cool. But so you had a soft target, a bunch of legislators that were being threatened to lose billions of dollars in franchise fees and so forth, and so they panicked. And it didn't no amount of last minute, and there were like 2 weeks in which the parties had a chance to try to influence the legislature. I'm guessing this had been kind of cooking in the legislature for months before this. It just wasn't really evident.
No, I mean, that's not the reporting that we have. I mean, certainly at some point, it was likely that I think it's actually really more like last year they bullied through, they pushed through these extraordinary changes to allow those contracts to overturn the Wallace decision. And I think that's when they figured out that, hey, we could just change the law here. They realized how much influence they had, and in that case, that last year.
So it may have taught them. So it
taught them how easy it was to do.
Right,
and so these are especially mounted this huge opposition last year, and it didn't make a dent, and they realized
Well,
we can do this now.
With all due respect, law professors don't spend a whole lot of money on legislators.
Yeah, we figured out that our voices are not as influential as we would have hoped.
Not as influential as expensive lobbyists threatening, billions of dollars in franchise fees.
Yeah.
So as I said, it was kind of a soft target. Now, in terms of the impact, and there's a couple other kind of dimensions to this, and I've said this before, is that shareholders will probably lose some protection. There's, there aren't as many, activists don't, try to avoid controlled companies. Okay. So there's, and the percentage of companies that are kind of controlled isn't that high, though it's changing because the definition of control just got moved.
Yeah.
Okay, but activists aren't going to see an immediate impact, though there's a couple of contingencies on that. Okay, and again, activists try not to get involved in lawsuits about this kind of stuff. So we're just trying to elect directors and try to improve oversight of underperforming companies. All right, and so in the next year, we're probably not going to see that much. But we talked about this earlier. It's not clear kind of what we mean by a transaction. Clearly a go private transaction. There's things that are clearly transactions, but there's other aspects of transaction. To what extent is this going to affect board elections? To what extent is it going to influence increasing use of these kind of private agreements with shareholders? That's going to really start to have an impact. But we're probably not going to see that for a little bit.
Yeah, it does.
It's going to take some time to react to this.
It does carve out, I think. I mean, again, it's new, we don't know. But and we'll see what companies try to argue. It does seem that it would carve out so that it doesn't really apply to the most obvious things that activists sue over. Like proxy contests, can't get on the ballot, things like
Books
that.
and records demands.
Books and records demand it applies to, but when activists sue over proxy contests, it doesn't look like it applies to that. It doesn't look like it would apply to actually like bidding wars over companies, those kinds of things.
Right. So when there's a public process that's kind of handled well.
Yeah, those kinds of things it appears are not subject to the law, although I don't know how the independent standards might interact with some of that. But other kinds of things it could. Right.
So I think, as much as it bothers me to sort of say we got to wait and see, because there's some things here that are, clearly, especially like, relying on exchange standards for independence, that's just horrible. Okay. There are some things where it may take a little bit of time kind of to unfold. And again, we have to see some cases. We're going to have to see some of our portfolio companies try to test these new standards in some ways. And assuming we can get it gets bad enough, we want to sue somebody over, assuming we can find a company, a firm to kind of take it for us, take the case. That'll be part of it. I've been kind of wondering, not as much as an activist, but just as an investor, what it's going to kind of mean for the state of Delaware and other states. There's if you're following this, Texas isn't sitting still. Nevada is kind of wondering how should we react to this. Are they viewing Delaware as a soft target here too? Yeah, and I don't know what to make of that. I was kind of wondering what you thought.
Well, okay, so it's complicated because I definitely think that pressure was part of what spooked the Delaware legislation. I mean, so what happened? I mean, there are a couple of ways you can think about this. So first, we just think about this in terms of Delaware. So we talked about the politics. It was so. There was so much lobbying just doesn't happen. I read a report 20 lobbyists. I don't know if I'm making that up. It was ludicrous. There were all these lobbyists who were lobbying the legislature in favor of the bill. There were competing websites that were set up, one side pro, one con. There were consumer groups that were getting involved. There were TikTok videos. Wow. Talking about this, from progressives. All the progressive publications were calling it the billionaire's bill. And I have to say, This doesn't happen. This isn't how Delaware law works. It's not supposed to be so explicitly political. And usually most normal people don't pay attention to Delaware law. This is the first time a corporate law got attention on TikTok. And, to some sense, since I've made it my life, that's kind of gratifying. But on the other sense, it's sort of a warning sign for Delaware. Right. I mean, I think the reason for this is right now, it's a very salient issue how much corporate managers, how much oligarchs like Elon Musk and Mark Zuckerberg, it's very salient how much power they have. And this law functionally removes one of the remaining forms of judicial oversight on their behavior. I mean, we all witnessed how the Delaware Court of Chancery might have been the first and one of the few judicial forums to ever tell Elon Musk no. And now the legislature just removed that last remaining form of oversight. And I think that theme resonates really broadly right now, even among people who don't really understand the details. And that's why the opponents of the bill were able to muster up this popular opposition. But I think that also broke something in Delaware. It can't pretend to be neutral and technocratic anymore. It just put on this display for the whole world to see that its laws are controlled by a legislature that's captured by corporate managers and especially by corporate controllers, by founders, by venture capital, by private equity, and absolutely it has to cater to those groups. I mean, Delaware would always have to cater to those groups because it needs to keep in corporations. It can't function if all the capital flees. But until now, Delaware was able to maintain this illusion that it was making a balanced law that took into account everybody's
Well, it wasn't
interest.
an illusion. The legislature really wasn't it? I mean, up until last year, if you include Noailles.
The changes simply were not, they didn't look like
Right,
this.
weren't politicized.
And so
right, yeah.
that veneer of apolitical expertise, I mean, it's just gone. And Delaware may retain corporations in the short term, but I think something was really damaged in the ecosystem surrounding corporate law, how professors think about it, how politicians think about it, how other countries, they invite Delaware judges to speak. And I don't know that that's like on the table now. So, I mean, I think it's going to have some far-reaching implications. And one of the interesting things is if Delaware just doesn't seem like the apolitical, perfect expert, that's when other states can start to get traction. So
right.
Texas and Nevada, you mentioned, they've decided to seriously try to compete with Delaware. Nevada's begun the process of creating business courts with appointed judges. That's going to take them a while because they have to amend their constitution, but they're trying. Texas already created business courts.
They have the business court there,
but
right?
They're very new, but they're already proposing to amend their corporate law to make it even harder to sue than Delaware has, which is what we law professors call the race to the bottom. They're
race to the bottom, right.
To insulate corporate managers from any shareholder lawsuits. So in Texas, one thing they're proposing is for shareholders to be able to sue on most of their claims, they need to hold 3% of the stock. Now,
a minimum shareholder requirement.
Yeah, so
that would be
for a publicly traded company, that could be billions. So it would they would place even more limitations on books and records access. And the Texas law has a thing where it would create, your company could create a standing independent committee, and you could get court blessing in advance. Yes, these directors are independent, so that no one could litigate that later if the committee approved a deal.
So you like apply to the Texas court.
Yeah,
for
you go apply to the Texas court for like
director.
these guys are independent, right? And if the Texas court says yes, then you would always accept them as independent unless new facts that were not presented at the time came forward that could never be relitigated.
Now, will there be? We've kind of wondered. Will there be states that investors will gravitate to? I think North Dakota isn't that the one where someone's trying to move out of there?
Carl Icahn changed. Yeah, I mean, here's the thing: the theory was supposed to be that shareholders will demand more protections, and they'll price capital lower if they don't get them, and so managers will naturally gravitate to the jurisdictions that have more protections so that they can have lower cost of capital. And I just don't think it works that way.
You don't think or it's not going to work so that like VCs, or initial seed and A round invest. When you're private still,
well, I think that what shareholders request. Are going to do, I don't think that it's going to be such a lower cost of capital that companies are really willing, like that the insiders who make the decision are going to risk the lawsuits. I think what we're much more likely to see are ever more bespoke contractual kinds of limits and protections. And when that happens, there isn't fiduciary litigation, there's just contractual litigation. And it doesn't necessarily have to take place in Delaware court, doesn't necessarily have to take place in a courtroom at all. It could be an arbitration. I mean, I think that is how you're going to see more and more corporate governance moving into these contracts. But I mean, the thing that keeps striking, what stands out to me is that as Texas and Delaware and Nevada race to make it even more impossible for shareholders to bring fiduciary duty claims.
Yes.
You could write a law that says shareholders cannot bring fiduciary duty claims, and that's very short and very easy, and we're done. But instead, they have to write ever more words to capture the principle that every possible avenue that shareholders could sue over is blocked. Instead of just saying shareholders
Let's just say it. Let's just come out and say shareholders can't sue over this stuff.
Exactly. So it begs the question, why? I mean, why are you writing paragraph-long, complicated, have to read through multiple clauses sentences when you could just say shareholders can't sue? And it's as though, to me, that these states and the corporations, they have this basic sense that the public would protest if they just openly admitted to completely eliminating shareholder litigation. They feel some impulse to hold out the hope that maybe some litigation would succeed somewhere so that it looks like there are basic rules that apply to corporate managers. But it's not true. They're taking away all the rules.
So rather than just come out and say it, let's sort of pretend.
Well, pretend. They want to pretend that these guardrails still exist.
We're going to create all these loopholes.
Exactly. Just pretend that there are these guardrails and we don't have them.
And they don't apply.
No.
All right. Wow. Well, there's going to be more to talk about, I think, probably in the next few months.
As we see. There are the pending cases to which this law doesn't apply. So we'll just, it's the new ones.
Right. All right. Well, we'll have to get ourselves to Delaware sometime soon. and try to talk to some people about this. Why don't we we'll take a field trip, do a little research one of these days. All right. So, but before then, we're gonna have to wrap up and maybe let our followers move on to other stuff here. All right.
Yeah.
Cool. All right. It's been terrific talking about all this, and we will return to Delaware, at least mentally, maybe physically, sometime soon. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is the Michael M. Fleischman Professor in Business Law and Entrepreneurship at Tulane Law School and an affiliate of Tulane's Murphy Institute. You can find me, Mike, at theactivistinvestor.com, and you can find Ann at law.tulane.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening. We'll talk again soon.